Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as anyone there in Las Vegas, and of course, anyone watching online, whether through Nellis or our YouTube station. With that, I will ask the committee secretary to please take roll.
Assembly members Cole. Here. Dalia. Here. Gonzalez. Here. Gray. Here. Hanson. Hardy. Here. LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadim.
Present.
Orentlicker.
Here.
Roth. Urick. Here. And Chair Miller.
Here, thank you. And we see Assembly Member LaRue Hatch is here. Please mark her present. And Assembly Member Hanson when she arrives. With that, just a few housekeeping notes. Please make sure you turn off your electronic devices. Again, committee information is available on Nellis, including the agenda as well as the phone number for today to call in if you'd like to make public comment or testify on a bill. And I'll provide you with that phone number right now. It is 1-888-475-4499. And today's meeting ID, when prompted, is 844-0095-0105. Again, we will have public comment at the end of today's meeting. We ask that anyone making public comment or testifying on a bill, please keep their comments to 2 minutes. You can also submit public comment before, during, or up to 24 hours after the adjournment of today's meeting. With that, we do today have a presentation in 3 bills. We will be taking the bills out of order. So we will begin with the presentation, then we will go to Assembly Bill 150, then Assembly Bill 4, and Assembly Bill 30. With that, we ask that all presenters also keep their presentation to 15 minutes, 20 minutes at max, because we do have a full schedule today. With that, I will go ahead and open up our first agenda item, which is the presentation. And just so you're following, because I know it feels like late to be having presentations, this was the presentation that was scheduled for last week. And of course, we had to move a few bills and presentations over due to the snow day and such. So with that, we have a presentation today on the overview of the Nevada Department of Sentencing Policy. So I will welcome up the presenters, give you all a few moments to get situated and comfortable. I ask that before you begin your presentation that you introduce yourselves, and as you state your name, please also spell it so we have it correct for the record. For everyone speaking today, please make sure you say and spell your name before you begin to speak. And with that, we are ready whenever you are.
Good morning, committee, Chair Miller, Vice Miller Marzola. My name is Georgia Powers, Georgapowers. I am the Executive Director of the Nevada Department of Sentencing Policy. Thank you for having us today.
Sorry. And my name is Jenna Bonacorsi, JennaBuonacorsi, and I'm the Deputy Director for the Department of Sentencing Policy.
All right. So the Nevada Department of Sentencing Policy mission is to promote an equitable and reliable criminal justice system by providing reliable criminal justice data, practical fiscal analysis, and comprehensive policy resources to lawmakers, stakeholders, and the public to ensure Nevada's sentencing and corrections policies and the Nevada criminal justice system as a whole are effective, data-driven, and resource-sensitive. Our core values, we dedicate ourselves to data that is practical, meaningful, sustainable, unbiased and nonpartisan, collaborative, and Nevada-focused. Currently, we have 6 positions in our office. The Nevada Sentencing Commission is housed within the department. The Nevada Local Justice Reinvestment Coordinating Council was instituted to help identify needs at a local level. Last session, the Nevada Sentencing Commission Misdemeanor Subcommittee was established to study misdemeanor sentencing in Nevada. NDSP has been tasked with developing a centralized database regarding sentencing and criminal justice processes. The Microsoft SQL Server Studio was the last step in this development. NDSP worked closely with the Office of the Chief Information Officer to create a Microsoft SQL Server Management Studio database, which after a year of planning and development is now up and running. This will allow NDSP to store, process, and query data more efficiently. One mandate of NDSP is to analyze various aspects of the Nevada Department of Corrections population. We review annual trends in the total population, broken down by category and offense group. In the past, NDSP and NDOC have mainly looked at the most serious offense when analyzing the population. Through collaboration with NDOC, NDSP has developed an all offenses data set, which reports every offense on an offender's current booking, not just the most serious. This allows NDSP to have a more precise understanding of sentencing trends in Nevada. We also break the information down by an offender's imprisonment status to determine trends over time. Another way we evaluate trends in the DOC population is to break it down by age group, which has led us into additional analysis. The Department of Sentencing Policy was asked by the Commission to examine the aging population of the Nevada Department of Corrections. The U.S. Department of Justice Bureau of Justice Statistics defines the aging prison population to be offenders aged 55 years or older. Studies show this population is more susceptible to costly chronic medical conditions. They typically experience the effects of age sooner than people outside of prison due to issues such as substance use disorders, inadequate preventative and primary care before incarceration, and stress linked to prison life. Industry research estimates the cost of housing aging individuals at 4 times that of the younger population. Here, we see the aging population versus those younger than 55 broken down by felony category. When we break the aging population down further, we can see that the majority are 55 to 64 years of age. When looking at trends in offense groups for the aging population, only violence has shown a continued increase. Outside of felony categories and offense group, we also like to look at other trends, such as number of offenses on current booking. Here we see the vast majority of offenders in the aging population have 1 or 2 offenses on their current booking. Prior criminal history is also a data point we review to pinpoint possible trends. This includes prior jail incarcerations, terms of probation, and prison incarcerations. It is also interesting to see how long the aging population offenders have actually served on their current bookings. Our research into the aging population led us into an analysis on medical costs within the NDOC and how that has compared to the population over time. In 2023, total medical costs for the Nevada Department of Corrections were $16,139,035.44, and the largest portion was hospital emergency room visits, followed closely by general office visits. After we completed the aging population study, Commission members were interested in the young adult DOC population, which is comprised of offenders 24 years and younger, to include juveniles adjudicated as adults. Here you see felony category trends for this young adult population, of which Category B makes up the most serious offense on the majority of bookings. While we expected to see the property and drug reduction due to AB 236, one thing our department found striking about the trends in young adult admissions was the reduction in admissions for violent offenders. We are continuing research into this age group. In the 2023 legislative session, collection of data regarding homicides in Nevada was transitioned to the Nevada Department of Sentencing Policy. Population size and homicides do not necessarily have direct correlation. Nevada has great disparity in county size, the largest ranging from just 736 people in Esmeralda to over 3 million in Clark. Clark County reported the highest number of homicides under NRS 170.750 for 2023. However, the per capita homicide rate is lower than that of other counties. Lincoln, Pershing, Nye, and Lyon, for example, each reported a higher homicide rate per capita. 8 counties reported no homicides for 2023. Here you see the final dispositions for the murder and involuntary manslaughter cases. In March of 2024, there were no incarcerations under the new fentanyl NRS. NDSP used hypotheticals to inform possible future outcomes. NDSP now has data on arrests and convictions under NRS 453-3387 regarding fentanyl and its derivatives through October 2024. Of the 50 individuals with arresting charges under the Nevada offense codes for fentanyl, only 2 were convicted under the original charge, and both were through a guilty plea. At the time of this report, neither had entered NDOC custody. However, updated information shows they have been admitted. Here are the Nevada Local Justice Reinvestment grant applications selected for funding. The state dollar column in this graph is the amount awarded from the $3 million available state funds. Governmental entities were required to provide a 30% match. This amount can be found in the match dollar column. All governmental entities, except the Las Vegas Municipal Court, provided an in-kind match of staff time. The Las Vegas Municipal Court provided a cash match, significantly extending the benefit to the grant's target population in Clark County. We are monitoring the grants closely at this time. We track NDOC long-term population, and one way you can view this is through the dashboards on the NDSP website. We have shown these dashboards before. However, there have been updates to the information available. One such advancement is information by county. Our current project is to make the new all offenses data available via these dashboards. NDSP was asked in the fall of 2023 if the department could duplicate the prior contract holder's prison projections for the state of Nevada. The Nevada Department of Sentencing Policy worked closely with NDOC, Parole and Probation, and the Parole Board to complete this report. NDSP intends to continue to publishing post-conviction population trends and projections as a neutral Nevada agency by utilizing our comprehensive understanding of Nevada criminal justice, proven open communication with Nevada criminal justice stakeholders, and consistent access to Nevada offender data. Currently, the statute requires an outside vendor to complete these projections. Here are samples of improvements we suggest for future projection reporting to include a 3-biennial look at post-conviction populations and projections on the fiscal year to better facilitate budget building processes for these agencies. Recommendations that have come through the department and the commission include continued financial support to the Nevada Local Justice Reinvestment Coordinating Council grant efforts for the 2026-27 budget cycle. Financial support should be given to the Department of Corrections and the Division of Parole and Probation to improve their respective data systems. Data is not readily available to the Commission and the Department to track the rerouting of justice-involved individuals due to Assembly Bill 236 of 2019. Methods of data collection and required submission of data should be considered. One statutorily required component of calculation, the 2018 JFA projection report, only projected NDOC populations through 2028. This is the last year that the projection of costs avoided report will cover a full biennium. This language will need to be changed. Coming projects for the department can include legislative session support and analysis through fiscal notes, ad hoc queries, and fact sheets, completion of the young adult offender analysis, habitual offender study, NDOC female population analysis, misdemeanor offense analysis, continued improvement to the post-conviction population projection model, continued advancements on publicly available dashboards. The Nevada Department of Sentencing Policy has been called upon and continues to be available to help identify how new or changed legislation may affect the NDOC prison population and recognize any possible unintended consequences. Our contact information is available here, and we are open to any questions you may have.
Thank you so much for your presentation. We will begin questions with Assemblywoman Gonzalez.
Good morning. Good morning, and thank you for being here and for your presentation. I just want to make sure I understand correctly. On the post-conviction population projection slide, is that saying that that is what is projected for the population of incarcerated people on that slide?
Yes, Jenna Bonacorsi for the record. Yes, that is saying that was with the model that had been developed in-house by the state of Nevada through our department, the projected population just for the total population. So in the actual report that we completed, we break it down much further, but for the purpose of time, we just provided the overall trend.
Thank you. May I have a quick follow-up, Chair? Sure. Can you speak to what is increasing this population? I mean, we've seen a decrease since really 2008, 2019, and it's projected to go back up. So I was just curious what you're seeing or what the prediction is there. Thank you.
Thank you. Jenna Bonacorsi again. DOC, while the overall population has seen a decrease since COVID numbers from 2020, the population decreased significantly, and also with AB 236. And so what we've seen since then has been a steady incline due to the fact that AB 236 and COVID kind of went into effect in the same year. It's hard to separate the population trends fully from those two. So as the population is leveling out, we are still determining what exactly is causing that. Part of it also has been the actual increase in the population of the state of Nevada in those past few years. So our department is looking into, now that we have a little bit of more time that has passed since AB 236 and seeing how some trends have leveled out, truly determining what is causing the steady increase back in the prison population.
Our next question is from Assemblymember Cole.
Hello, thank you very much for the presentation. My question is on your recommendations slide, the third bullet point. You talk about the data not being readily available to the commission for the rerouting of justice-involved individuals due to AB 236. Just, can you give me a little bit more flavor of what that would be, like what you're looking for?
Thank you. Georgia Powers. The problem with looking at where the populations have gone due to Assembly Bill 236 is that while they're not going to prison, the penalties were lessened, so a lot of people are going to jails. So are we really saving money, or are the jails having that? Are they going on probation, more people, and so parole and probation is absorbing those costs? And so we don't have a lot of local law enforcement data. So we don't know how many people necessarily went to jail for these same lowered penalties.
I believe that concludes our questions, although let me just make sure. Yep, that concludes our questions. So with that, thank you for your presentation. Thank you for your flexibility in rescheduling as well. I will go ahead and close this agenda item. I also would like to make a note to the committee secretaries. Please mark Assemblymember Hanson absent excused. Thank you. Again, I did mention we are taking the agenda out of order, so our next item will be Assembly Bill 150. Assembly Bill 150 revises issues relating to tribal judges. So we will give Assemblymember Ordlicker a moment to get himself and co-presenters settled, and then whenever you all are ready, you may begin.
Okay. Good morning. I am Assemblyman David Orentlicker, representing District 20 on the southeast side of Las Vegas. Thank you for the opportunity to present Assembly Bill 150, a bill that some of you may remember that was part of Assembly Bill 369 from last session. The need for this bill was brought to my attention by Tribal Judge Patricia Lindsay, who is joining me this morning to discuss the bill. Inevitably, judges make decisions that displease many people being judged, and people appearing before a judge may try to influence a decision through intimidation or threat, or may retaliate for an adverse decision. Accordingly, state law provides a number of protections for judges, but these protections are not provided for tribal judges. Judge Lindsay can discuss the serious consequences for tribal judges from the gap of the law, and then I'll go through the bill in detail.
Thank you all for allowing me to testify before you again today. And thank you especially to Assemblymember Orentlicker for continuing to champion this cause that is near and dear to my heart.
Judge Lindsay.
My name is Patricia Lindsay, Patricia, last name Lenzi. I am a member of the St. Regis Mohawk Tribe. I serve as Chief Judge for the Winnemucca Indian Colony Tribal Court. I'm also a conflicts judge for the Urington Paiute Tribe here in Nevada, and I serve other tribes in other states, including the Cedarville Rancheria of Northern Paiute Indians and the Chemehuevi Indian Tribe. My work takes me across jurisdictional boundaries of many tribes through Nevada and California. I am a citizen of the state of Nevada and the United States. I reside in the jurisdiction of Douglas County. I don't reside on the lands of any specific tribe. Tribal court cases include all civil and criminal cases that state courts see and range from probate to protective orders to homicide. I want to share with you two specific situations I have experienced to explain why I am here to support the amendment to NRS 199-300 contained in sections 1 through 7 of Assembly Bill 150. 11 years ago today, on February 20th, 2014, I was serving as a conflicts judge for the Colorado River Indian Tribes in Parker, Arizona. That day, I was also appointed as chief judge at Cedarville Rancheria in Alturas, California. I was sworn in telephonically because I was in Arizona. The very first hearing was also held telephonically for that reason. Zoom and WebEx were not really used back then. So picture me in Arizona presiding over a case over the phone while everyone else involved in the hearing was present in the tribe's meeting room. This is the only reason I am alive to provide testimony for you today. During our first hearing, the person who was the subject of a housing eviction court hearing pulled 2 9mm handguns from her backpack, killed 4 people present, and wounded 2 others. She cut the throat of one of the people after her gun jammed. She stabbed others. I heard the entire crime, and I could not stop it. Criminal jurisdiction at that tribe, because it's in California, rests with federal and state of California governments. Tribal judges in California are treated under the law the same as any other private citizen, although they have an Assembly Bill 32 that is up this year that may change that. I learned that others who were possibly involved in the mass shooting and sympathetic to the shooter lived in Reno. I sought to have a confidential license plate for my car and that of my husband. I learned that here in Nevada, tribal judges are treated the same under the law as all private citizens. I was told I had to obtain a court order to permit confidential plates here. I had to show I was the victim of domestic violence or stalking related to that to qualify. I fell into a legal loophole. In 2023, I was appointed as a conflicts judge for the Winnemucca Indian Colony. I have since been appointed their chief judge. I presided over a very contentious housing eviction case. In 2023, when this bill was last before the legislature, you received the order from the former chief judge recusing himself due to threats. And 2 years ago, you also received a letter of support for this same amendment from the Winnemucca Indian Colony. While the case moved on through the tribal court, I became the object of a campaign attempting to convince me to stop serving as judge, disqualify myself, abandon my work as a judge for that colony. There were Twitter and Facebook posts of my image informing people about my personal life, my family, my work, information from my LinkedIn profile, a letter writing campaign to my tribe and every single tribe where I served as a judge, asking to fire me. It was cited as a reason that the Washoe tribe felt that my continued service as their chief judge posed a risk to their community members. Meantime, several incidents occurred on the colony lands, including charges of assault on federal officers, among other charges. As I said, the chief judge disqualified himself due to threats, and those cases were all assigned to me too. Anonymous letters were mailed from Reno and Vermont to me at my home and my work addresses. The return addresses indicated they were sent from the Winnemucca Indian Colony or even from my husband. Letters were sent to each of my neighbors and their adult children by name at their respective addresses, demanding the neighbors hunt me down at the store where I work, come to my house to demand that I resign from the Winnemucca court. The letters urged people, and I'm quoting, to do whatever you have to do to stop her. Understandably, my neighbors were disturbed by this. A suspicious vehicle sat in front of my neighbor's home, observing my house at one point. I called the local sheriff to report stalking under Nevada law. I was told to report it to tribal police because it was a tribal matter, even though the entire incident happened off tribal lands at my home and my neighbors' homes in Douglas County. To this day, no detective has investigated the incidents. Seeking help under Nevada law left me even less protection than a private citizen because local law enforcement did not understand their jurisdictional authority. I reported it to federal authorities, but it falls within an exception under federal law too. Tribal judges at that time were treated as private citizens, not afforded protections offered to federal judges or hearing officers. Here in Nevada, only one of the tribal judges at all of 27 tribes here in Nevada resides on the reservation where she or he serves as a judge. The rest live off colony or off reservation. Some of us live in other states. Some are native, as I am, others are non-natives. Tribal judges regularly drive state and county roads to and from tribal courts. This amendment would recognize the service we provide and offer a clear direction for law enforcement investigators faced with the same situations I previously experienced. I thank you for your time and consideration of this very important amendment to Nevada law that will lead the way in protecting tribal judges. I urge you to pass the amendment to NRS 199-300 contained in sections 1 through 7 of AB 150. My only request is that you consider changing the language to simply say a tribal court judge or a tribal court judge for a federally recognized Indian tribe, because the language, as written, would exclude protection for any tribal judge attending training at the National Judicial College in Reno, or if I were to leave the Nevada tribes and still be a judge for the California tribes, I would no longer have protection. Thank you.
Thank you, Judge, and I'm so sorry for your experience, and hopefully we can prevent other judges from facing the same thing. As we indicated, there's a gap in our law. We protect judges, but we don't protect tribal judges. So the goal of this bill is to extend the same protections for our local and state judges to tribal judges. So if you look at Section 1, it adds tribal judges to the list of public officials who are protected from threats or intimidation. This section of the law deals with threats toward judges that would try to prevent them from carrying out their duties, to coerce them or unduly influence them. Sections 2 and 3 deal with assault or battery against judges or other officials, and it raises the penalties for people who assault, that is, attempt to use physical force or actually do use physical force of battery, and it increases the sentence for the perpetrators if it's a judge or other official. Sections 4 through 6 allow the personal information of tribal judges, that's their names, their home addresses, their email addresses, their phone numbers, addresses of partners or minor children, to be maintained. That this information, if it's in the records of Secretary of State, county or city officials like clerks, assessors, recorders, allows for the confidentiality of that personal information. And then Section 7 allows judges, now tribal judges, to request an alternate address on their driver's license or identification card. So we have these protections already in law. The gap is we don't apply them to tribal judges. As the judge indicated, the language as written limits it to judges who are part of a tribe that's located within the boundaries of the state. So I will want to present an amendment to remove that language so it covers cases of judges who are, in this case, judges for tribes that aren't located in Nevada. The other change is that I'd like to propose, right, this came to my attention because of Judge Lindsay, but the same risks apply to court staff, tribal court prosecutors, tribal court public defenders. So I'd like to amend the bill to include other law enforcement for tribes.
And,
So that,
and the court clerks.
right, court clerks.
Sorry.
So that concludes our presentation, and we welcome your questions.
Thank you so much for that. And yes, Judge, we are all deeply sorry for the trauma that I know that you still work through. And to the families of everyone related in that horrific incident. With that, we do have a few questions, and we will begin with Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for bringing this important issue and for telling your story. I know it's not easy to relive. My question is about the amendment. I absolutely appreciate that we need to protect court staff as well. My question is, are there protections for non-tribal court staff currently in law? Would we just be matching this, or do we need to extend those to all court staff?
Thank you for the question, Assemblymember Arnott-Licker. Yes, those are already there. It includes court staff, prosecutors. There are other categories of public officials, but these are the ones we would, so this would match what's there for judicial, law enforcement, but doesn't match all the officials that are in statute.
Thank you for that question, because we know court staff, hospital staff, school staff, anyone in those buildings are vulnerable at times as well. With that, I don't see any additional questions, so I will open it up to support. Anyone, we will begin here in Carson City. Anyone that would like to testify in support of Assembly Bill 150, please come forward. Again, please remember to state and spell your name for the record.
Good morning, Chair Miller and members of the committee. Jennifer Noble, Jennifer on behalf of the Nevada District Attorneys Association. We'd like to thank Assemblymember Orentlicker for bringing this piece of legislation forward, and also to commend Judge Lindsay for sharing her experience. I hope we don't have to hear any more stories like that this session, but we hope that you will consider this important piece of legislation. Thank you.
Good morning, Madam Chair and members of the committee. My name is Sarah Adler with Silver State Government Relations. We are proud to represent the Pyramid Lake Paiute Tribe and the Duck Valley Shoshone Paiute Tribe. And also in the Adler family history, Ernie Adler was at one point a tribal judge for the Fallon tribe. And although he did not suffer anything like the harassment and danger that was described, if he were a judge today, I would want these protections for him and our family, as do the tribes that we represent. Unfortunately, there's still going to be risk of harassment when serving as a tribal judge, but tribal judges certainly deserve the same protections as our civil and criminal judges. Thank you very much.
Good morning, Chair Miller, members, Brett Scolari, Strategies 360, BRETTSCOLARI, here on behalf of the Las Vegas Paiute Tribe and the Reno Sparks Indian Colony. Thank you to Assemblymember Orentlicker for bringing this legislation. We certainly support the bill and also support his amendments and support the idea of giving these protections to tribal judges and court employees. Very important, and we appreciate your consideration. Thank you.
Not seeing anyone else in Carson City coming forward, and there is no one in Las Vegas right now. Broadcasting, will you open the phone lines, please?
Chair, the public line is open and working. There are no callers at this time.
Okay, thank you. I will open it up for testimony in opposition of Assembly Bill 150. Not seeing anyone approach. Broadcasting, will you open the lines, please?
Chair, the public line is open and working. There are no callers at this time.
I will go ahead and open it up for testimony in neutral of Assembly Bill 150. Not seeing anyone approach. Broadcasting, will you open the lines, please?
The public line is open and working. There are no callers at this time.
Thank you so much. With that, I will welcome the judge and the assembly member back up for any final closing remarks.
Here we go. Patricia Lindsay, for the record. I really want to thank you. If you add protections, I did do a little research at the request of Assemblymember Orentlicker, and if you add the protections for the staff, I think you'll probably be the first state in the country to actually do that. I'm on a number of groups with judges. I've asked around, and at best we get protection for judges. Sometimes for staff is considered, but you'd be the leaders. Thank you.
Assemblymember Orentlicker, thank you very much for your consideration of this bill, and thank you, Judge Lindsay, for bringing this important problem to our attention.
Thank you all.
Thank you so much. And Assembly Member, we look forward to seeing your conceptual amendments. With that, I will go ahead and close the hearing on Assembly Bill 150. Our next bill hearing today will be Assembly Bill 4. AB 4 revises provisions relating to probation and lifetime supervision. With that, I will go ahead and give our presenters a few moments to get settled. Again, just a reminder, please, before you speak, introduce yourselves, state and spell your name. And we are ready whenever you are.
Good morning, Chair Miller, Assembly members of the committee. I am Tamara Jackson, Tamrah, Jackson. I am the Department of Public Safety, Parole and Probation Chief. With me today is Deputy Chief Aaron Evans. We are pleased to present AB 4 to you today. The Parole and Probation Division is seeking the ability to petition the sentencing court or state board of parole commissioners for the release of a person sentenced to lifetime supervision. In addition, we are hoping to clarify provisions related to good time credits. Lifetime supervision is a unique program designed for individuals convicted of certain sex offenses. This term of supervision begins after the individual has completed their term of probation, parole, or prison. They currently become eligible to petition the board for release from lifetime supervision after 10 years. Unlike probation or parole supervision, lifetime supervision has fewer conditions the person must follow. They do not forfeit their rights to search and seizure. They are not required to report to the Division of Parole and Probation, and they are not required to submit to random drug testing, to name just a few. For example, possession of pornography or other items of concern with this population will not be identified due to the inability to search a home, a phone, or a computer. The primary focus of the conditions of lifetime supervision as outlined in 213.1243 has become to ensure that their residence is approved by the division. Much of the remainder of the conditions related to lifetime supervision have become difficult to enforce and apply equally among the population. The limited amount of enforcement the division takes on these cases is consistent with those taken by local law enforcement agencies as required by NRS 179D 550. This bill will provide an outlet for the division to request a release from lifetime supervision for those individuals who cannot otherwise comply with the requirements of NRS 1760931, which requires that an individual under lifetime supervision petition the court or board under specific conditions of compliance to be considered for release from lifetime supervision. Unfortunately, there exist circumstances under which an individual may be unable to meet the requirements of the language as described in NRS 1760931, Section 3, due to indigency, infirmity, geographical limitations, or a general inability to comply. One of these circumstances currently includes a requirement for a person to be deemed to not pose a threat to the safety of others, as deemed by a licensed clinical professional who has received training in the treatment of sex offenders. For individuals not currently undergoing treatment, the cost of this type of exam could reach upwards of $2,000. The current language provides no alternate method of release, and therefore persons under lifetime supervision may remain supervised with no hope of ever being released. In addition, any individual who has been deported will remain supervised by the division indefinitely. The addition of the provisional language would allow an alternate path for the petition of release from a term of lifetime supervision that can be initiated only by the division. If granted release by the court or board, this new language would allow for the administrative closure of lifetime supervision cases maintained by the division without the affected individual having to perform much of the administrative work themselves. Release from lifetime supervision does not change sex offender registration requirements. NRS 179D 550 requires registration with a local law enforcement agency to include residence, place of employment, and student status. It also requires the local law enforcement agency to take appropriate action to ensure registration compliance. This results in duplication of work between parole and probation and the local law enforcement agencies. The lifetime supervision sex offender caseload will continue to rise and will require increased resources to monitor this population, a population with very limited conditions as previously described, conditions which are already being addressed by the local law enforcement agencies. The second section of this bill relates to good time credit. NRS 176A 500.1 allows for a court to order a period of probation that may either be indeterminate or fixed. In 2007, the Nevada State Legislature added a section to this chapter that eventually evolved into Section 6 of the current law. Section 6A and B state a probationer must be allowed a deduction of days from the probation term if they meet certain criteria, meeting their court-ordered financial obligations and being involved in employment, education, or rehabilitation. The division believes the legislative intent was that all probationers, regardless of whether they have a fixed or indeterminate period of supervision, should be eligible for credits that reduce the length of time of supervision. Some courts order a fixed term of probation, expecting the probationer to serve exactly that amount of time under supervision. However, when the probationer earns credits towards their term pursuant to Section 6, a conflict in statutory language and interpretation is evident. The adjusted language would clarify and minimize the existing conflict. I want to thank the members of the committee today for listening to us, and we are prepared for questions.
Thank you for your presentation. With that, our first question will come from Assemblymember Roth.
Thank you so much, and thank you for the presentation. My question is in regards to this opening up the sex offender statute. And please forgive my ignorance. I have not done research on Westlaw this morning. But I would love to see this expanded to individuals who are serving life tails for old habitual criminal adjudications. And I'm wondering why the choice was made to open up NRS 176, and is there an avenue for individuals who are serving life tails for habitual criminal adjudication?
Tamara Jackson for the record. In this instance, we were looking at the lifetime supervision sex offenders only partially due to the limited ability to supervise them, and we did not consider lifetime parole at this point in time. It's something we could consider in the future.
Thank you so much.
Thank you. Our next question is from Assemblymember Gray.
Thank you, Madam Chair. Instead of allowing them to petition to be released from the requirements, is there a way to allow them to basically go through the same process but be put in an unsupervised parole or probation status for lifetime? So there's still two agencies ultimately responsible for them, but it relieves the burden, and it just the thought of somebody that's been sentenced to a lifetime of supervision, and it just kind of doesn't sit too well with me.
Thank you for the question, Aaron Evans, AARONEVANS, for the record. They more or less are very minimally supervised today. As the chief discussed, they don't have a search condition. So like a probation or parolee, if we have cause, we can search their house, their phone, whatever. On these lifetime cases, that doesn't apply. So in actual practice, all we're doing is verifying their residence on an annual basis. We go knock on the door, they still live at that place. We can't go in unless they invite us in. That's very rarely the case that they want us to come in, so we check them off the list. We've done that registration verification for the year. That's the bulk of the supervision we do now. We could choose to supervise them even less, but then what's the point? I mean, at that stage, if we're not following up on the addresses or making sure that they're still registered, we don't see the benefit of like having kind of an unsupervised kind of bank caseload of them sitting there. It's a resource that we have to employ people to, follow up on them, or if they've been deported, they're checking ICE records to see if there's any reentry. And they're kind of minimally supervised as is. So after 20 years of what we would call lawful behavior, right? No new convictions for a crime that's a threat to public safety. They're probably not a high risk to reoffend and can be let off of this minimal supervision that we're providing. And I know the term lifetime supervision has a lot of connotations, but it's not life, because they can petition to get off at 10 years if they meet some criteria. And the supervision is very different than traditional parole or probation supervision.
If you could, just for helping us understand better as well, could you give us more, and I know this would be a very generalized example, but what a typical situation of a person looks like on lifetime parole or probation? Because again, this isn't generally someone who went to prison for a year, someone who's, 24 years old. This is generally people have spent more time and years in prison. Would that be accurate?
Aaron Evans, for the record, that is correct. So lifetime supervision starts after probation, if it was a probation case, or after parole, if they went to prison and come out on parole, or after prison if they do their entire term in prison. It's a special sentence, like I said, outside of the criminal sentence. There is no underlying sentence that if they violate the conditions of lifetime supervision, there isn't an underlying sentence that they're beholden to, right? If you are sentenced to 3 years of probation with an underlying prison sentence of a year and you violate your probation, you're going to go back and do that year. That's not the case with lifetime supervision. If they violate lifetime supervision, it's a new criminal offense. It's a new felony. And that's another thing we can discuss if we want to. But back to your question, the average age, I think, of we did some numbers. As of today, there's 92 individuals that have been on lifetime supervision for 20 years or more. Lifetime supervision was added to statute in the late 90s, so it's new. You know, it's only been around 25 years or so. 92 active individuals on lifetime. 25 of those have been deported, so we will never know anything about those cases unless they re-enter and are caught. 20 of those 92 are in a warrant status already. They had violated their terms of lifetime supervision at some point, and we had submitted for a warrant and received that warrant. Most of those warrants are going to be for failure to register and for failing to update their address with us. So that leaves about 47 potentially eligible people as of today that this could affect. The average age of those people is about 60. They've been on supervision with us for 20 years. Now, I didn't go through each one of them to see if they would actually be eligible. We didn't run criminal histories to see if they had new convictions. But going through a couple of them, I found one individual, his supervision has been transferred out of state. He's in, I don't remember, Ohio, I think. And I was going through the case notes, and he's entering hospice care, and because he's been ill for years. And in this case, if we could, administratively petition the court or board for his release from lifetime, we could then release the Ohio authorities from their obligation to supervise this individual. Mm-hmm. Cases like that is what we're trying to help. Indigent offenders, to the chief brought up in her opening statements. If they have to get an evaluation that says they're not a risk to reoffend if released from lifetime supervision, which is not a risk to reoffend in general, but a risk to reoffend if released from lifetime supervision. If they haven't been working with a counselor or they have to get a whole brand new psychosexual evaluation, those can cost thousands of dollars. And so we have indigent offenders who live, paycheck to paycheck or retirement to retirement, and they really have no means to petition through the language as it's written now. So what we're asking for is to give us the ability, if they've maintained basically a crime-free period of 20 years, which is a long time, to relieve the burden from them and relieve the burden from the state to invest resources into these individuals who are not our highest risk individuals, if they've gone 20 years and shown that they're not out committing crimes.
Thank you so much for that. Our next question is from Assemblymember Urick.
Thank you, Chair. And your question actually hit my first of a two-part question. So thank you for asking that, and thank you for addressing that issue on the evaluation and the explanation and rationale for that decision on how you're approaching this policy. My other question related to, because you mentioned both of those in your presentation, involved that issue, and then you mentioned something about individuals who were deported. Can you just expand or help me understand that issue as well, please?
Tamara Jackson for the record. So I shouldn't say many. Some of the individuals will be deported, obviously, as a result of the crime they've been convicted of. However, they're going to remain on that lifetime supervision, so we actually have to monitor those caseloads. And currently, we actually don't even have staff that are specifically assigned to that, so we have to put that job on additional staff. Really, they're just monitoring to see if they're going to come back into the country, things of that nature. But again, we're going to have that caseload continue to rise year after year after year, because the other part of that is we will never be advised if and when they might pass. So we will be monitoring these people for 100 plus who knows how many years.
Thank you. We have another question from Assemblymember Gray.
Thank you, Madam Chair. And I realize you just said you don't know, but could you get us the number of folks that are either deported or going to be deported on lifetime supervision?
Aaron Evans, for the record. We can get you the exact number. I'm fairly certain it's around 450 that are on this program of lifetime supervision that have been deported. So to the chief's answer, that number is just going to continue to grow as obviously these are severe convictions that lead to lifetime supervision, likely to be deported. And again, we're now investing administrative staff to monitor these cases, but we will provide exact numbers to you, the committee.
Thank you, Madam Chair.
Thank you so much. And with that, we will, I see no additional member questions, so I will go ahead and open it up for testimony in support of Assembly Bill 4.
Good morning, Chair and members of the committee. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, Clark County Public Defender's Office. This bill recognizes that people can change. Those who have demonstrated decades of law-abiding behavior deserve a fair chance to move forward without unnecessary supervision. Keeping them on lifetime supervision, despite no violations, drains resources that could be better used for individuals who actually need the oversight. And as the presenter explained, this sort of petition is nothing new. Someone that's already on lifetime supervision can do this after 10 years, but as they explained, there's a lot of obstacles that can come with it. So this just allows parole and probation to make the same request, but after 20 years of good behavior. And as a public defender, we don't always agree with parole and probation, but we can't deny that when our clients are on supervision, they know our clients best. And if they're supervising someone for 20 years, they know someone for 20 years, and that person has not been in any trouble for 20 years, then they are in the best position to know whether they should continue on supervision and simply be able to make that request for them to be released. 20 years can be a whole lifetime for people. This bill is about rehabilitation and public safety. Thank you.
We are still in support for Assembly Bill 4, so if there's anyone wishing here in Carson City to come forward. If not, I will go ahead and open up the lines. Broadcasting, please open the lines for support testimony.
Chair, the public line is open and working. There are no callers at this time.
Okay, thank you. Then I will open it up for testimony in opposition.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association. That's Johnjones. And the Nevada District Attorneys Association views this bill between two lenses. One is truth in sentencing, and the second is public safety. Now, with respect to truth in sentencing, victims are told at sentencing that their defendant will be subject to lifetime supervision, and that this defendant has to meet very narrow parameters in order to get off of lifetime supervision. Further, and this is important, lifetime supervision requires an order that the defendant have no contact with the victim or witnesses who testified against the defendant in court. There is a strong tool for us if that is ever violated, being a Category B felony. With respect to public safety, the legislature created lifetime supervision to ensure that sex offenders who pose a risk to safety to others would be monitored out in the community after having served their sentence. And it is not all sex offenders, it is the most serious of sex offenders. And it is currently supervision for life unless three criteria are met. 10 years have passed with no violations, and they are found to not likely to pose a risk to the public, as determined by a licensed clinical therapist. While the limiting language proposed in AB 4, if they've not been within 20 years convicted of an offense that poses a threat to the safety or well-being of others, that sounds good, but in fact, that's a term of art. It is not any conviction. It is a specific set of convictions that include crimes such as new sexual offenses. However, if an offender after a psychosexual has been found that drug issues or alcohol issues contributed to their abuse, and they could have 20 years worth of convictions for possession of controlled substance or DUIs, and that would not affect their ability to get off of lifetime supervision.
We are over 2 minutes. Can you wrap it up, please?
In essence, this bill would let high-risk sex offenders off of lifetime supervision. There's no getting around it, even if they pose a risk of danger to the public. We cannot support that. With that, Chair, I am happy to answer any questions the committee may have.
Thank you so much. We will continue in opposition testimony. Not seeing anyone else here in Carson City. Broadcasting, will you open the lines, please?
Public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for testimony in neutral. If there's anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Broadcasting, will you please open the lines?
The public line is open and working. There are no callers at this time.
Sorry, not sure where I went for a moment. So thank you for that, broadcasting. With that, I will welcome up the bill presenters if you want to make any final comments.
Thank you, Tamara Jackson, for the record. We just want to reiterate that a term of lifetime supervision already allows for release after 10 years. The division is just seeking a separate opportunity after 20 years for those who have not been convicted of an offense that poses a threat to the safety or well-being of others, which those are already listed in that statute, and may not have the ability to comply with the requirements of the professional exam due to indigency, infirmity, or geographical limitations. Thank you.
Thank you. With that, I will go ahead and close the hearing on Assembly Bill 4. Our next bill is Assembly Bill 30. Assembly Bill 30 revises provisions relating to record of defendants who have been found incompetent. So with that, I will give you a few moments to settle in, and then please introduce yourselves and say and spell your name.
Good morning, Chair Miller and members of the committee. My name is Drew Cross, D-R-E-W-C-R-O-S-S, and I am the State Forensic Program Director. I'm accompanied today by Dr. Ronna Dillinger, Deputy Administrator of Clinical Services. Thank you for the opportunity to talk with you this morning about Assembly Bill 30. We'd like to offer a brief overview and then be available to answer any questions. AB 30 relates to the process of obtaining pertinent psychiatric and medical information from detention centers for individuals court-ordered to the division to receive competency to stand trial restoration treatment. Nearly everyone admitted to the inpatient unit comes from a detention center, and correctional staff can be valuable sources of information. For some individuals, the behavioral, medical, and mental history records from the detention center is the only history we might be able to gather, since some individuals, due to their mental health struggles, cannot provide a reliable history, which can hinder treatment efforts. The receiving of these records is for the limited purpose of formulating an individualized treatment plan, and there is no intent to gather criminal history. Having the observations of detention center staff can help in some of the gaps in knowledge regarding history of mental health symptoms, attempts at treatment, interpersonal dynamics with peers and staff, any history of trying to harm themselves or others, and so forth. Passing this bill will provide a better opportunity for continuity of care and can contribute to increased efficiency in forensic services. The wording of AB 30 is closely modeled after NRS 178453, which allows for the division to obtain records from the Department of Corrections for similar reasons. AB 30 will lead to consistency across the state with regard to obtaining these records, provide the opportunity for more timely treatment, and contribute to the overall clinical case conceptualization. This bill is only in relation to individuals who have been court-ordered to undergo competency restoration treatment at Lakes Crossing Center or Stein Forensic Hospital. Thank you for your consideration of this bill, and we welcome your questions.
Thank you. Our first question will be from Assemblymember Cole.
Thank you very much. I appreciate what you're trying to do with this. My question is, what about for juvenile justice? I would imagine having that information from that system would be better, and that's not under the Department of Corrections, as I understand. So are you asking for that information, or can you add it? Like, is it Department of Family Services?
Drew Cross for the record. Our experience is juvenile records are typically sealed. However, we can explore this and get back to you.
I have a question. When you say that pertinent information that would be related to support that individual, can you explain? Because to me, it feels like when we're requesting a warrant, we have to be specific for what we're looking for. So when you say pertinent information, can you explain who or how would define or determine what would be pertinent?
Certainly. Drew Cross for the record. Information that pertains to their behaviors in the detention center, the potential for self-harm. Do we need to be aware of any sort of suicidal type history? Any behaviors or treatment related to their mental health symptoms. But I'd also like to, if allowable, give our clinical deputy a chance to answer some of these questions as well.
Yes, please.
Ronna Dillinger for the record, RONNADILLINGER. Just to add on to Mr. Cross's response, as far as the records deemed pertinent would mostly help inform the case conceptualization. So this is also going to include medication, medication attempts, if there's a medication that worked or didn't work, if they're resisting medication, how they're getting along with correctional staff, how they're getting along with their peers, behavioral stuff that would be important for us to know as they come into the inpatient facility.
And so then, am I also understanding as you're saying this, so we're looking at the behaviors that would be identified, but now as you're speaking, would this be determined by a clinical professional, a healthcare professional, determining which behaviors should be included?
Ronna Dillinger for the record, thank you for the question. I don't know that there's an identified person that usually determines what records would be helpful, so the entire purpose is to help us with restoration, case conceptualization. So that is often up to the evaluators to determine if there's information they might want from the detention center that they don't have about the history. We're not looking to gather every single piece of paper on somebody in the detention center. And so it's a little bit of a judgment call, I think, on both ends. As far as the information that we're asking for, and the detention center to look through their records and help us figure out what would be most helpful for restoration treatment.
Okay, thank you for that. We have a question from Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. This is really just a clarifying question, kind of off of that. So the purpose of this is, and correct me if I'm wrong, is to share medical information between medical providers. So the medical providers at the jail to the medical providers at NDOC, is that correct?
Yes, NDOC and now the detention center is correct.
Thank you. Our next question is from Assemblymember Gray.
Thank you, Madam Chair. Yeah, I'm kind of bewildered, just even from a standpoint of continuity of care, why those records wouldn't follow them to begin with and keep a new provider from having to start over or with minimal information. So what's the reason now that those records aren't following them? I mean, it's pretty clear what you're asking for. It's information that may assist in evaluating and treating. I mean, that seems like it's pertinent just for continuity of care.
Drew Cross for the record. That's a great question. Oftentimes our clients are in the throes of a mental health episode and are not always inclined to sign release of information, which of course delays us gathering the needed documents to generate a treatment plan for that person.
Thank you so much. I don't see any additional questions, so I'm going to go ahead and open it up for testimony. Those wishing to testify in support of Assembly Bill 30, please come forward. Not seeing anyone here in Carson City. Broadcasting, will you open the lines, please?
Public line is open and working, and there are no callers at this time.
Thank you. Then I will open it up for opposition of Assembly Bill 30. Not seeing anyone approach in opposition. Broadcasting, will you open the lines?
The public line is open and working, and there are no callers at this time.
Anyone wishing to make neutral testimony, please approach. Not seeing anyone. Broadcasting, will you open the lines for neutral?
The public line is open and working, and there are no callers at this time.
Thank you so much. Then I will welcome the bill presenters up if you have any final remarks.
Drew Cross for the record. Chair and members of the committee, we would like to thank you for your time, and we have no further comment.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 30. Next on our agenda is public comment. So if there's anyone here in Carson City that would like to approach and make public comment? Not seeing anyone. Broadcasting, will you open the lines, please?
If you'd like to provide public comment, please press *9 to take your place in the queue. Chair, their public line is open and working, and there are no callers at this time.
Thank you so much. I will go ahead and close public comment, and we have concluded our work for today. So I will adjourn this meeting and see you all back at 8 a.m. tomorrow morning.